Hi, everybody. I'm Diane Brady. I'm here with Duncan Levin, who is, of course, a former federal prosecutor in the Manhattan D.A.'s office under Cyrus Vance and Robert Morgenthau. He is now the managing partner of Levin Associates. Thanks for joining us.
Thanks for having me on, Diane. Appreciate it.
So we are talking about, of course, former President Donald Trump, this indictment and the gag order. Talk a little bit about, first of all, how common this is, Duncan. Is this just a matter of course that you get indicted by the Manhattan DA, you're going to face a gag order?
Well, gag orders are extremely common in criminal cases, but they're only common in cases where there's a reason to have a gag order. And really where you see them is in cases where there's a high-profile defendant or a crush of pretrial publicity, because the point of a gag order is really not to quiet down the parties. I mean, of course, this all has to be balanced with the defendant's First Amendment rights to speak and to defend himself also in the court of public opinion. But within that balance, the court is going to want to maintain a tight grip on the proceedings and make sure that a potential jury pool is not tainted, because everyone in Manhattan right now is a potential juror to this case. Mm-hmm. And so the judge is going to want to make sure that the parties aren't speaking out of turn in order to try the case before potential jurors, before they're even sworn in for a trial.
And there is no nuance in these situations. Is it an all or nothing, or are there degrees, in essence, of a gag order? You can discuss some elements of it. I'm curious how much wiggle room there is.
Right. So you can always discuss the next court appearance and what is it going to happen on the next court date. There are certain basic things that all the parties will be able to discuss. But when it comes down to it, it's going to be to the extent that the judge issues a gag order, it's going to be something that is very broad ranging to try to stop any of the litigants from actually discussing the evidence and discussing the facts underlying the indictment in any real detail. And so maybe the parties will be able to discuss, here's what the charges are, but they won't be able to get into, here's what the defenses are, here's why it's wrong, and they won't be able to try the case, because remember, at the end of the day, he's entitled to a trial. And both sides are entitled to set the rules about what happens at trial. So there's going to be motions about what comes in at that trial, and the judge may decide that certain things don't get to come in before the jury. So he doesn't want potential jurors hearing evidence that ultimately may not come in at trial. That's the point of it. And so any level of detail and granularity is something that the judge is not going to want the parties talking about.
Now, on paper, when I look at these penalties, it reminds me of when I lived in Beijing, and it was basically like a 25-cent fine for smoking. Somebody would pay the fine and they'd keep the cigarette in their mouth and they'd go about their merry way. $1,000 is such a small amount. What's the worst case scenario here if you continue to basically flout an order like this?
Well, a court order is punishable by contempt of court, and there's fines, but there's also jail time available. And the judge has the ability to put somebody into jail for up to 30 days for violation of a court order, which nobody would obviously want that to happen to them. But we have to remember that these are punishments that are being meted out by the judge without a grand jury, without any charges. This is part of the judge's, they call them plenary powers, to be able to put somebody in jail. That's a very unusual circumstance where one person can throw somebody in jail. And that's why it's capped at such a low number, 30 days, or the fine is capped at such a low number. It's just because it's one person deciding to do it. It's an important person. It's the judge. But at the same time, the judge doesn't have the ability to just put someone in jail for years. That being said, repeated offenses will probably become more and more harshly punished. But don't forget, there are other penalties that are available as well. And one example I'd give you is that there was a posting on Truth Social, the social media platform, where Mr. Trump posted a picture of himself holding a baseball bat next to the head of D.A. Bragg. That in itself, at the moment, there is no gag order. So it doesn't violate any court orders, but there is a separate New York State statute called menacing, criminal menacing. And I think arguably postings like that cross the line between free speech and criminal behavior, where behavior is meant to try to threaten somebody and make them feel like they are going to get harmed or they are going to be killed. That could cross the line into criminal menacing. That's something where a separate criminal charge could be brought. So I think we have to wait and see how it all plays out. Let's remember, number one, he has not been charged formally with anything. Number two, there is no gag order. And number three, he hasn't broken it yet. So there are a lot of hypotheticals here. But while the court doesn't have broad-ranging powers to throw anybody in jail for long periods of time, it's still a pretty severe punishment. And this judge is a no-nonsense judge who I don't think is going to tolerate anybody speaking out of court. Now,
you've been in the courtroom for many high-profile trials yourself. One question that comes up would be, let's say this, in the event of it being a jury trial, how potent is the argument? It must come up a lot. Could the former president get a fair trial in a jurisdiction where he received so little of the vote? I don't know if there's any precedent in this case where we certainly have somebody who is already challenging the legitimacy of this system itself.
I've been trying cases in Manhattan for much of my professional career, and I think there's a big distinction between who you would want to vote for and be your president, and who you would give a fair trial to. I think there are a lot of very smart people living in Manhattan who may not wish to have him be president of the United States, but have a moral compass and could fairly hear a case and be fair to him, even if they don't want him to be president. And so I think at the end of the day, that is an argument that is very likely to fail. I do expect that the defense will put in a motion for a change of venue. For example, for those of your viewers who may not be so familiar with New York City, the borough of Staten Island is generally considered very conservative, very Republican. I expect that they'll probably make some kind of motion to have the jury pool at least come from Staten Island, or maybe for it to be moved to Staten Island in some way. It may be that he's able to persuade the appellate division, which is the appellate court, about some of this. Time will tell, but I think at the end of the day, those political arguments are more rhetoric than anything that's going to actually be granted by this court.
So as an observer, Duncan, how are you... I've been intrigued by the fact that certainly there's some precedent where this is a president who, was told to appear before Congress, did not do it, and really the repercussions were pretty minor. If that pattern repeats itself here, because we're already hearing rhetoric about the court system not being legitimate, that this is a political witch hunt, are you concerned about any sort of broader ripple effects if there's no consequences to some of the actions that may take place?
Yeah, I mean, I can leave some of the prognosticating to political commentators on the attack on our institutions, which I think is a real one. As a former prosecutor, I'm pretty disturbed to see envelopes of white powder being sent over to my former office. And I'm pretty disturbed at the rhetoric of seeing a baseball bat at the DA's head. And so I think these things do matter. Words do matter, and lead to violence. So I'm, as a citizen, as a former prosecutor, as a defense attorney, I'm concerned seeing these things. But as a legal matter, I don't think that any of that is likely to change the outcome of this case. There are rules that are time tested and that are really enshrined in the law of New York State that have been tested over time. And I just don't think that any of that rhetoric is going to make any difference in the way that he's treated. I think the judge is going to try his best to see that the case is handled fairly. I think the prosecutors will as well. And I think this is something that he's just going to have to go through, like the countless other thousands and hundreds of thousands of criminal defendants who are called before courts every year.
Citizen Trump, that's the way it should be. So thank you for joining us, Duncan.
Thanks so much, Diane. Appreciate the opportunity.
Thank you.